I'm Sanjay Chaturvedi, and today we are going to have very interesting topic. But of course, and we are taking a subject which is talk of the town, the force majeure. Now, the term Latin word force majeure, but basically it is a clause in the agreement or in the contract which says that if one of the party is not able to perform because of some reasons, and these reasons are listed under the force measure. In the force measure, because today is the era where we are into such natural calamity, a pandemic, and such listings which we have actually agreed to, and bit very specifically as far as the real estate is concerned, we have covered the force majeure in various documents, agreement for sale, conveyance deed, sale deed, and so on and so forth, various MOUs. So whenever there is a force majeure clause, that means the person, either party, or very specifically, maybe the seller, as far as the real estate is concerned, is allowed to deviate from his performance, say possession, because of the list of 4, 5, 6 items. Usually, even in the model agreement for sale in RERA and in MOFA or in various other part of the country, we have such type of force majeure is invariably appointed or as a covenant in the agreement for sale. They are inserted, and uh, how far corona or COVID-19 going to be the force majeure, or whether any other item which is in force majeure, there we are going to discuss today. This is a live telecast. You can always put a question to me in the chat box, and later also you can email me on editor@saptakala.com, and I'll be happy to take your answers. Now let us begin with the subject. Force majeure is basically a Latin word. And before I go into the whether the corona and the lockdown and COVID-19 situation is the force majeure, let me give you a very quick and basic citation. In this citation, that you will understand that how far the force majeure is the detrimental to somebody's performance, and the courts have accepted the force majeure, including the RERA tribunal. Now, in one of the case in the RERA tribunal, Mumbai, that is Maharashtra tribunal, RERA Maharashtra tribunal, one of the case was that the project was in Thana Godbandar Road. And in Thana Godbandar Road, some time back, Honorable Bombay High Court had actually refrained the Thana Municipal Corporation to give water for construction projects for 6 months. That was the stay in some other matter. The Bombay High Court had actually given an injunction on some such activity to the construction water to be supplied by the TMC. Now, one of the matter has gone into the RERA, and subsequently it has graduated to the tribunal, and the tribunal has recognized that the builder would have actually not did anything wrong, and it was beyond his control that the water was not there in the for the construction work, and for that particular period the honorable tribunal has actually reduced the quantum of the delay interest, although the delay interest was for some other reason they have not allowed, maybe for TDR and other. But for such type of days, for that particular 6 months, the Honorable Tribunal has said that yes, it was the matter of law build well, where the Honorable Tribunal Maharashtra has allowed the force majeure. Now, this is our usual force majeure where there is no COVID-19 or no such lockdown as such is concerned. Now, coming back to our subject, we are going to talk about the performance under the agreement for sale, and of course, we are going to speak on the lease and rentals and what are the owners and tenants' rights and how far they can negotiate, or what are those legitimate rights of the tenant and the landlord in this type of situation as far as the force majeure is concerned. Now, COVID-19 has brought many questions for force majeure. Genuine cases where the performance is not possible because huge migration of the construction labor in the country, and you know that it was impossible for the construction sites to retain them, and the government although have lifted the lockdown rules, though it was on 23rd March 2020 it was imposed, but somewhere around 8th April or 9th April the government of Maharashtra has lifted. So did the other states. They have lifted that ban, and the government lifted the lockdown rules on the 8th April or 9th April to 2020, and issued an SOP for the construction workers. Their accommodation and food and social distancing and everything has to be the responsible of the developer and the builder. And one of the biggest developer like L&T in the country has declared that their sites are operational 90%. In the public, they have said that their sites are operational up to 90% in the country, and in the month of May 2020 itself. So May big construction sites and other sites may have started accordingly. But labor is one of the biggest force majeure, because it is that you have seen it that they have migrated from one state to another, and maybe because of whatever months they were migrating into, but the construction sites were facing a labor problem. So it's a genuine one. You don't need to prove it in the court of law, and you need not to prove that the construction workers were not there, because it is a COVID 19 period, and you and I know for sure that the construction workers were not available. One thing is certain, there is a thin line to decide force majeure in contracts. Even the Supreme Court has given a definition for the force majeure. The lease for per se, if I take it, the lease have also become a major talk of the town for the subject. The two landmark judgments of the Supreme Court, there is one is the Raja Dhruv Dev Chand versus Raja Harmonder Singh AI 168, Supreme Court 1024, and Sushila Devi versus Hari Singh 971, that have left no scope for doubts or debate as far as the force majeure is concerned. A joint reading of these two cases, which says that uh, Section 56 of the Indian Contract Act 1872 does not apply to lease, as it is a completed conveyance different from an extraordinary or executory contract, and events which discharge a contract do not invalidate a completed transfer or the lease. See, lease is basically a transfer for some time, the title for some time. It is not that force majeure finds no place in the Transfer Property Act. In Transfer Property Act also, clause E of section 108 says that if by fire or by flood or violence or any army mob or other irresistible forces or any material part of the property be wholly destroyed. See, the property of the lease property has to be destroyed, then only there will be a force majeure. That is what the Transfer of Property Act, which under 108 says. And uh, you can say destroyed or rendered substantially and permanently unfit for the purpose of for which it was let. The lease shall, at the option of the leasee, be void. So the option is the leasee or the landlord, where he should say that okay, now the property is not livable. So hence only if the force majeure event is of such nature, then the lease property is substantially and permanently destroyed. It can be voided at the option of the leasee. Sorry, tenant. The Delhi High Court, uh, in the very landmark judgment dated somewhere around 15 July 2016, very recently, in the matter of Airport Authority of India versus Hotel Leela Ventures Limited, offers a uh, you can say solution on the subject. It says that the leasee sought remission in the lease rent as the project has become commercially not viable on the account of recession in the hospitality industry, triggered by the terrorist attack in Mumbai 2008, and then people were not coming and all that. The lease under the question was for a duration of 30 years, and the lease rent was calculated as a percentage of the revenue. So it was percentage on the revenue, so the revenue was not there. So the Honorable Delhi High Court held that the petitioner claim to be it is absolutely a false and frivolous as an abuse of the process of law, because it may be noted that the special leave petition preferred by the Hotel Leela Ventures against the Delhi High Court in the order, it is absolutely failed one. In this trade, under Section 37 of the Indian Contract Act, the parties are specifically enjoined upon to perform their promises unless such performance is dispensed with or excused under the provision of the Contract Act or of any other law. One such instance is when the performance of an act becomes impossible without any fault of the promisor. Section 56 deals with such intense and embodied of doctrine of the frustration of contract. The courts have consistently held that the contract cannot be frustrated on the grounds of commercial difficulties, inconvenience, or hardship. So you must have the acumen for completing your project. You are signing such contracts, so you cannot say that now it is beyond my control. So some such permission, some eventualities must have been calculated, and you must know that what is going to come. Um, Mostly in SRA projects where you know that there are some eventualities comes in, uh, people don't vacate, or there are some permissions or some court litigations happens, and such all things has to be calculated before you start the project and go in for some agreement for sale. Also, this 60 days, or you can say those first lockdown period of after 25th, 23rd, 25th March 2020, and it has lasted somewhere around 4th May or 5th May of 2020. As per the Supreme Court's order that was written in the writ petition, civil writ petition of 3 of 2020, cognition for extension of limitation was given by the Supreme Court, and it is today also. The limitations where you sometimes there is a limitation of 2 years or 3 years or 5 years in the filing your cases, there the Supreme Court has so motu taken the cognition and given the limitation, because this is a pandemic where the courts needs to understand that the force majeure or the limitations also needs to be extended. And in its order on the 18th May 2020, Maharashtra RERA very specifically they were came with very first such in the country. And Maharashtra, RERA recognized the pandemic immediately. And on the 18th May, in Order 14th of 2020, Maharashtra RERA has invoked the force majeure. And what it said that the order with reference to the advisory issued by the Central Advisory Council, those who have actually uh, given an advisory to the RERA different part of the country, saying that you must at least give 6 months extension to the compliances and the completion dates, and another 3 months if it is up to the prerogative of the state government to give more 3 months. So it is all together 9 months were suggested. Maharashtra have taken 6 months, and other states have also have taken 6 months. Some states have gone for the 9 months, but that 3 months were given that the prerogative. Now, accordingly, in keeping in the central government advisory councils and government of India in the under section 37, they had given a mandate to the RERA specifically, a force majeure period of 6 months from 15th March to 14th September. If your date of completion is falling after 15th March, then only you are eligible for 6 month, mind you. And if it is before that, you are not supposed to get that benefit of force majeure. Now, in the order number 13 of 2020, Maharashtra RERA has already revised the project validity by 3 months, and they have said that the validity is extended by a further period of 3 months. That means 6 months. Then, accordingly, the 6 month rules were given. Now, for further extension beyond after 6 months for adversely affected projects, concerned promoters will have to apply in accordance with the provision of the RERA. That means Section 7, subsection 3, the leverage were given, but that was the only 6 month period extension was given in MARERA and in other RERA also. The time limit for compliance under Section 11, which became due anytime during the force majeure period after 15 March to 14 September, and stand automatically extended. So you don't need to actually apply to RERA and ask for the extension. The force majeure period will be treated as a moratorium period for the purpose of the calculating interest under Section 12, 18, Section 19, subsection 4, subsection 7 of Section 19 of the Act. The work of the registration and other document would be as per the normal conjunction and actual normal process of the RERA. The dates of the possession mentioned in already registered agreement for sale shall be deemed to be extended by the force majeure period. That was the order given by Mayor RERA. Now this is a very important point, because agreement for sale, if is saying that your possession date falling in this that particular 6 month, then it has automatically extended the date of the possession. So force majeure is being taken into consideration, and the force majeure was accepted by even MARERA through this order. Now, due to non-functioning of the concerned offices and working of the transfer of titles and conveyance and etc. has been adversely affected, the compliance under Section 17 or maybe become a during the force majeure period is allowed to be completed in a period extending till the expiry of the force majeure period. So, and the order also cited the famous writ was under the Neel Kamal Realtors Suburban Private Limited, which has in the writ petition with the Honorable Bombay High Court, which in para 115 of its order has observed that the object or the purpose of the real estate is because they want to complete the project, they don't want to actually jeopardize the project, and the extension has been given. Now, the order has cited that keeping in view the spirit of this order and to ensure that the available liquidity in the designated RERA accounts get utilized on priority for the completion of the project, and refund whatever it is it become due during the force majeure period is allowed to be executed in a period extending up to 1 month after the expiry of the force majeure period. So a month also been given by the RERA. Now, force majeure is basically a covenant of the agreement for sale, where the person is not having any control, and if he can show that if there is a already order, the courts have given the order for limitations and the moratorium periods, and the certain effects which has actually affected the projects needs to be understood under the force majeure. Now, various RERA, including Majeure, have asked the developers whether your construction in writing, whether your construction is on or no, whether you are having some difficulty or no, and all such communications through SRO, the self-regulatory organizations, have actually assisted RERA in understanding whether the COVID-19, as far as the lockdown, how far the force majeure is acceptable or no. Now, force majeure is a legal term. When there is a covenant in the agreement for sale, you must actually understand what is the flow. Many people or developers have also written the economy recession. Economic recession may not be beyond control, because it is the acumen. You have to understand that what market is going to be completed, and somebody is paying you. So the economic recession may not be in force majeure. But of course, if there is any labor problem, or maybe any stay or injunction of the project construction, or maybe some government policies where you are not getting the permissions, and situation like COVID-19, where the entire world is actually suffering, the projects are not going ahead, construction labor is absolutely a problem, then whatever can be proven in the court of law can also be availed under the force majeure situations. So, coming back on the subject of the lease and the rentals. The lease and the rentals, live and license, we are mostly executing agreement under 11 months or 33 months, or sometimes 55 months. Such type of agreements, those which are enforceable, the tenant has to give the rent. There is no go, because it is a lease which is transferred. It is a temporary transfer of the title and for a particular use. Many landlords and tenants have actually, almost 90-95% of them have actually agreed for some rental discount or some moratorium period, or maybe sometimes people say that okay, don't reduce the rent but give me some time. So such type of understanding between the landlord and the tenant did, but it was out of the purview of the agreement. If you stick to the agreement, then the landlord can take all the action whatsoever under the law to vacate the premises and give a notice for sure. And if suppose the tenant also paying up to mark, or maybe it is up to the further agreement with the landlord or the property owner, then the tenant may retain the property. And yes, it is a difficult time for us, and landlords have understood. It is not that invariably people have actually given discounts and time to pay. But then if you ask a law point, then the landlord and the property owners are correct and in the right path and the right side of the law. If they ask you, if the tenants are not paying, and then if they ask you, likewise, I will give you example. Say you have taken a loan from bank, and although there was a RBI 6-month moratorium period was given, but 7th month onwards, if the banker asks you to pay your EMI, you cannot say no. and then it may go to the NPA and you may face the music. Suppose if you don't pay your loans and EMI or whatever. So under the law, if the tenants are not paying, then they are vulnerable to be vacated the premises, and the landlord or the property owners can ask the tenant to vacate the premises. I hope you have enjoyed this series of study forum. I will invite some more people on and in the subjects coming very interesting. Some subjects we are researching on, and you can also send us some list of subjects where we can invite people to talk to, and we will have some good expert opinion also in this particular forum. Till then, thank you very much, and don't forget to like our channel and subscribe it. Bye bye.